And we have a lot to discuss because this panel is about prosecution and civil suits of presidents and former presidents. I'm David Sklansky. I teach at the law school here, and I'm very pleased to be moderating this panel because I can't think of three better people to discuss these topics than the three scholars who are seated to my left, and I'm going to briefly introduce them. Then we're going to hear some 5 to 15 minutes of remarks from each of them. Then we'll have a little discussion. Then I'm hoping during the last half hour we'll have a discussion that includes questions from the audience. So immediately to my left is Professor Kay Levine of the Emory University School of Law. Kay teaches and writes about criminal law and criminal procedure. She is an empirical and a doctrinal scholar who focuses on the operation of criminal law in the United States, especially in state courts, like, for example, the Fulton County, Georgia Superior Court, where former President Donald Trump currently faces a racketeering indictment along with more than a dozen other defendants. To Kay's left is Professor David Straus of the University of Chicago Law School, who teaches and writes about constitutional law and directs the University of Chicago Law School's Supreme Court and Appellate Clinic. Professor Straus helped represent President Clinton before the Supreme Court in the civil case brought against President Clinton by Paula Jones, and he represented a bipartisan group of 3 former attorney generals as friends of the court in Morrison versus Olson, arguing that the Inspector General statute was unconstitutional. And to David's left is Professor Saikrishna Prakash of the University of Virginia School of Law. Sai teaches and writes about constitutional law, presidential powers, and foreign relations. He's the author of 2 important books about presidential powers, Imperial from the Beginning, The Constitution and the Original Executive, which was published by Yale University Press in 2015, and The Living Presidency, an originalist argument against its ever-expanding powers, which was published by the Belknap imprint of Harvard University Press in 2020. So I think what we're going to do is go alphabetically. So we'll start with Professor Levine.
Well, thank you so much. It's particularly fun for me to share the stage with David Sklansky because I met him when I was a candidate on the law school market, when he was affiliated with a different school in California. But we've been friends and distant colleagues, I think, for more than 20 years at this point, so it really is a pleasure to share the stage with you. Many thanks to Mike and to Morgan for inviting me to join this event. I'm grateful to have the chance to participate in this wide-ranging conversation about this very strange circumstance we find ourselves in, a circumstance where a former president is being prosecuted by 2 states and the federal government for crimes that are in some way alleged to be connected to his political office and his desire to continue to seek political office. So as many of you know, New York prosecutors have charged Donald Trump with crimes that took place before he assumed office as a way, allegedly, to help him secure the 2016 election. In Georgia, he has been charged with crimes that occurred while he was a candidate for office as a way to help him win re-election in 2020. And of course, the federal government has its own version of that indictment as well. In Florida, the federal government has accused him of crimes that happened once he left office for reasons that are as yet unknown but might be related to a desire to assert leverage, perhaps on future office holders. So these multiple prosecutions of the former president are in so many ways unprecedented, and this inspires many people in this room and many people across the country to think about, or perhaps even lose sleep over, what these prosecutions might mean for our constitutional order or for the office of the presidency more generally. There's only been one reported arrest of a previous president in our nation's history, and that was for a much smaller infraction. Ulysses Grant was arrested in 1872 for speeding in his horse-drawn carriage. But he was not formally charged by the prosecution, so that arrest went nowhere. And as far as I can tell, Nixon was never formally indicted, although there was a draft indictment underway at the time that he resigned and by the time he was by President Ford. So former President Trump is the first president to actually be charged with a crime in our nation's history. And the crimes against him loom so large in our national consciousness that they allow us to consider how the criminal law and politics collide in new ways. So while many people at this conference come at these questions perhaps from constitutional law angles, I come at them because of my background and my training from the criminal law angle. For me, these unprecedented prosecutions give us the chance to think seriously about prosecution, particularly prosecution in our state courts, where 90% of prosecutions occur. How it begins, how it progresses, and how defendants are treated along the way. So to begin, there is no constitutional or statutory basis for presidential immunity for acts that fall outside the scope of the president's official duties. This means that even someone who used to be the president is just like all other defendants when charged with a criminal offense, particularly in the state courts. Since the treason trial of Aaron Burr in the early days of the Republic, the Supreme Court has consistently held that criminal courts can exercise personal jurisdiction over a president. The president must comply with criminal court orders to produce documents or to testify in a federal or state criminal proceeding. Moreover, as far as I can tell, there is no law that prevents a state from prosecuting a current or former president for crimes committed within the state's borders. So if we take the issue of immunity for former presidents off the table, it's important to recognize that while former President Trump has many advantages that most defendants in criminal courts don't have, and while his charges are certainly uncommon, he is in many ways just like all other defendants who are charged with crimes in state court. And for that reason, the set of cases currently brought against the former president gives us an opportunity to examine how our state criminal courts function. I've spent many decades studying these courts. I practiced in these courts. But for many people, these trials provide a first look at what goes on in our state courthouses every day. So for example, this past fall, the former president had to appear at the county jail in Fulton County in Atlanta after he was indicted by the Fulton County District Attorney's Office for a wide-ranging conspiracy. This meant that he had to come to Atlanta, a city he otherwise might not have visited, at his own expense to take time off of work in order to meet this obligation. And in the county jail, he was booked, which required him to get fingerprinted and to have his photograph taken for official court records. And those fingerprints and photos will forever be in Georgia court records. Even if he is eventually acquitted of all charges, just like other defendants in that circumstance, his surrender and booking documents will not be erased from law enforcement databases. They might pop up when those databases are consulted by future landlords or mortgage lenders, and perhaps even dating websites if he needs to avail himself of those services. In the New York case, where trial began a couple of weeks ago, the former president has had to attend court every day, or a bench warrant will be issued for his arrest. The court calendar preempts all other obligations for every single person who is named as a defendant in a criminal case, even when this is inconvenient. Now, unlike most defendants, the former president is getting Wednesdays off. But still, 4 days a week of doing nothing other than sitting in the criminal courthouse can feel like a significant burden on a person's time. And now let's consider what his daily experiences in the New York courthouse include. The former president has to sit at counsel table in a hard wooden chair for hours on end. There's no food and drink permitted. He has to listen to testimony and lawyer argument, much of it arcane and not very interesting. And perhaps most importantly, he has to listen to unkind things that are being said about him, and he is not allowed to respond in real time. He is not permitted to speak inside that courtroom except when specifically addressed by the judge. This kind of enforced silence is a real challenge. For all defendants, it seems to be especially challenging for the former president. If he speaks out of turn or if he utters expletives when witnesses say things he doesn't like, he has been warned that he could be locked up for contempt. Professor Malcolm Feely has called this litany of courtroom experiences a form of punishment in and of itself, separate and apart from the formal punishment that could be imposed after conviction for a crime. Professor Feely made his observation 40 years ago, studying the misdemeanor courts of New Haven, Connecticut, but his insights apply just as much today to the modern courthouses of New York and Georgia as they did to the older courthouses of New Haven. Defendants charged with crimes must submit to the way that courts do things, no matter how frustrating or alienating or humiliating those practices might feel. Submission to courthouse rules is not usually how we think of presidents behaving. During his time in office, the President of the United States is considered by many people to be the leader of the free world. But when he is a defendant in a criminal case, none of that matters. His status as a defendant takes precedence over every other status. It colonizes completely. The contrast between the judge and the defendant in a criminal case is stark, to say the least, even when the defendant is a high-profile person. And this is because the courtroom belongs to the judge and not to the defendant. It is the judge's name on the door and the judge's staff calling the calendar. The judge sets the rules for behavior and has the authority to punish people who disregard those rules. The judge is the person for whom all other people will stand and sit at the bailiff's orders. The judge is the person addressed with an honorific. The defendant is simply called the defendant, whether he is wearing an orange jumpsuit or a $10,000 Rolex. Being subject to the judge's complete authority in the courtroom can be a challenge for defendants everywhere, no matter what sort of life they lead on the outside. For defendants whose lives are marked by multiple layers of disadvantage, subjugation by the courthouse community might feel like nothing new. But for defendants who are used to being in charge of whatever room they enter, who typically set the terms of who speaks and when and on what topic, it can be frustrating. For a defendant who was once elected to the highest office in the United States, being told what to do by a local state court judge must be nothing short of infuriating. It seems to turn the world of privilege on its head. In what universe can a local judge tell the former leader of the free world to sit down and stay quiet? But in the state court universe, this pattern, this hierarchy, is not only possible, but it is embedded in our constitutional design. Our principles of federalism allow the states great leeway over the handling of crimes that occur within their borders, irrespective of the defendant's status. And certainly, even if a defendant wins on a motion to remove a case to federal court, it remains the state that is prosecuting him. The courthouse is, after all, the grand leveler. Defendants with money and power can have a smoother path through the criminal process, but the rules of the courtroom apply just the same. And if we believe that some of those rules are inconsistent with or do harm to our ideas about justice, about how people ought to be treated no matter what they've been accused of, we should recognize this as a problem for poor defendants as well as for rich and powerful ones. So for some Americans, the former president's trial in New York right now and the future trial in Georgia might be their first chance to see a real prosecution in the state courts. And what they see might challenge their preconceived notions about how prosecutions and state courts work. Some of those people might have once subscribed to a bland, undifferentiated commitment to law and order. They might have previously given no thought at all to the legal standard underlying the bringing of charges or to the enormous growth in prosecutorial power that we have witnessed since the Nixon administration. Before Trump's trials, they might not have cared one bit about the rights of the defendant, assuming that anyone who was hauled into court must be guilty of something because police and prosecutors can be trusted to do their jobs appropriately. So for some Americans, the treatment of the former president in currently the New York State courthouse might therefore be somewhat upsetting. They might for the first time contemplate whether something is seriously wrong with the legal business of the criminal courts in this country. Hopefully, some people who feel this way will feel inspired to more deeply look into the way most cases are handled and the way most defendants are treated. And if they take a closer look, they'll see that most defendants being prosecuted in our state courts are actually faring much worse than the former president. They have far less ability to retain sophisticated counsel, to avoid pretrial detention, and to impose and leverage delay in their favor. So once the facts about how the criminal courts work surface and get wider attention through the American population, I'm hopeful that some of the people expressing concern about the way the former president is being treated in this prosecution, some of those people might become supporters of groups that are lobbying for a smaller criminal justice footprint and care about the need for more robust protections for defendants across the board, not just for high-profile defendants, but for those who cannot afford sophisticated counsel or sophisticated social media campaigns. A higher level of engagement on issues of criminal justice reform brought about by the prosecution of the former president would, to me, be a silver lining, no matter what happens, the outcome of these prosecutions. Thank you.
So Professor Levine approaches the collision between criminal law and presidential powers and prerogatives from the perspective of somebody who is a scholar of criminal law and a former practitioner of criminal law. Professor Prakash approaches these questions and the questions of civil proceedings against presidents and former presidents from the opposite perspective, somebody who's spent his career spending a lot of time thinking about presidential powers and prerogatives. So we'll hear next from Professor Prakash.
Well, thank you so much. It's wonderful to be here with you today and wonderful to be part of this august panel. Thanks to Michael for inviting me, and thanks to the Con Law Center for having this superb conference. I'm actually going to focus on prosecutions and say nothing about civil suits, but I'm happy to take any questions you might have. I don't know if I'll have good answers, but I'm happy to hear the questions. I think there are so many dimensions to the matter of prosecutions of presidents. I think one dimension is incumbents versus former presidents. One is private acts versus official acts. A third is the structural implications of the grants of power to the president in the Constitution versus Congress's power to create federal crimes versus the state's powers to create crimes. And then finally, matters of interpretation. When should we read a generic federal criminal statute to apply to the official acts of constitutional officials, including the presidents? So let me begin with incumbents versus former presidents. I think everyone believes that former presidents can be indicted, prosecuted, and punished. I think even Trump's lawyers, President Trump's lawyers, concede this point, at least in some respects. What about incumbent presidents? Can they be prosecuted while they're in office? The OLC took the position, the Office of Legal Counsel took the position during the Nixon administration and again in the Clinton administration that presidents in office could not be indicted, could not be prosecuted, and could not be punished. And they made a structural argument, in part resting upon the impeachment clause. Professors Amar and Kalt have this view as well, that you cannot indict, prosecute, or punish a sitting president. I think if you have this view, it has implications for what can be done by the federal government to Donald Trump should he become president again. I think it would imply that any prosecution would have to be halted and any punishment would have to be, I guess, you have to give a temporary reprieve of sorts from those punishments. Why does the OLC have this view? Why do Amar and Kalt have this view? Because they think indictment, prosecution, and punishment essentially incapacitate a president, and they don't believe that that's permissible under Article 2. And they argue essentially that impeachment must precede a punishment for a sitting president. That is to say, you have to impeach and convict, remove, and then you can indict, prosecute, and punish. I think the OLC is mistaken. I think a sitting president can be indicted, prosecuted, and punished. The first two are certainly distracting. I don't think they're necessarily incapacitating. The last can be incapacitating because, of course, punishment can include a prison term or worse. But not all criminal punishments involve incarceration. Some of them are just fines, and it's not clear to me why that would be incapacitating at all. But if all three are incapacitating in some way, if we were to stipulate that, I think the Constitution has a rule that provides for that situation, which is that the vice president takes over, right? When the president's not able to function as president, the vice president takes over. And that solves the problem that the OLC and then Amar and Kalt find in the Constitution. And if there's this express constitutional provision that deals with the situation, I don't know why we would need to infer a immunity from the president from indictment, prosecution, and punishment. And so I think that's the constitutional answer to a situation where the president's being indicted, prosecuted, or punished. If, in fact, the president is not able to function as president, that's the solution, and we shouldn't infer any sort of immunity while the president's in office. I think I might add that, if you think this is intolerable in some way, the answer, I think, is a statutory solution. I believe Congress can provide a temporary immunity of whatever sort it wishes to a president or to other officials, including the vice president and justices, et cetera, just by statute. And there's a Soldiers and Seamen Act that provides immunity of various sorts for members of the armed forces. And I guess maybe one could make an argument that it covers the president. I haven't heard that argument made. But the more general point is that Congress has the wherewithal to deal with this problem. Both the Constitution and Congress have the ability to deal with this problem without inferring this immunity. What about private acts versus official acts? For private acts of the president, I think there are no constitutional issues with prosecuting a former president. I'm not sure anyone thinks there is. What about official acts? I think for official acts, the matter is far more complicated. There is, I believe, a rather limited immunity for the simple act of using presidential power, say pardoning, vetoing, appointing, commanding troops, commissioning officers, proposing legislation, et cetera. That is to say, if the statute tries to criminalize the mere act of vetoing a bill, I think that would be problematic. And you can get there in one of two ways. You could believe that the grants of power in Article 2 themselves create this immunity, or you could believe that it's not necessary and proper to carry into execution any federal power to criminalize the presidential act. And so either Article 2 creates the immunity or there's no authority for Congress to enact the statute. But I think when you go beyond that, I think it's possible to say that some official acts can be criminalized. I think if Congress were to introduce a mental state of corruption, my intuition is that a corrupt pardon, a corrupt veto, or a corrupt appointment could be barred by statute and therefore sanctionable by statute. Treason and bribery are two vile crimes, and both are mentioned in the Constitution. I think federal officials can be prosecuted for treason and bribery, just like you and me, including the president. I further suppose that treason in particular can rest on official acts. If a general tells a brigade to stand down and not engage with the enemy because the general hopes the enemy wins, that strikes me as treason. And what is true for the general is true for the general of generals, the commander-in-chief, or so it seems to me. A commander-in-chief can betray his country or her country. I think Charles II was thought to be bribed by Louis XIV to betray his nation's interests. And so they had an example of someone committing something that would seem like treason, but for the fact that the English crown could not be prosecuted at all, right? So in my view, the Constitution does permit Congress to criminalize the use of a power mentioned in the Constitution, at least if it adds the element of corruption or wrongdoing in the act. And so that it's possible that the acts mentioned in Article 2 can be the basis of a prosecution if the statute does more than just simply criminalize the act itself. It adds some corrupt element to it. And I think that turns on a sense, perhaps, that the Constitution implicitly forbids people from using their powers for corrupt reasons, even though the Constitution itself doesn't say that. And then I'll end with matters of interpretation. Most criminal and civil statutes provide general rules of conduct for the public. The court has created various rules of interpretation that effectively exempt official acts from the application of these rules, and I'm thinking here of Franklin versus Massachusetts with respect to the Administrative Procedure Act. Here's what the court said: out of respect for the separation of powers and the unique constitutional position of the president, we would require an express statement by Congress before assuming it intended the president's performance of his statutory duties to be reviewed for abuse of discretion. And so that was this question about whether you should review statutory decisions of the president under the APA, and I think what's true for statutory decisions would be true for constitutional decisions a fortiori. And I think that's I think the court's sort of wrestling with that question in the case that's currently before the court, and I'll end with that.
Thank you. So Professor Prakash has advocated for a relatively narrow view of the immunity of even a sitting president from criminal prosecution, and people who agree with him on that often point to the unanimous decision of the Supreme Court 25 years ago in Clinton versus Jones that sitting presidents are not immune from civil lawsuits. So one of the many reasons why we're fortunate to have David Straus here with us today is that Professor Straus helped represent then President Clinton in that litigation. So we'll now hear from Professor Straus.
Thanks, David. Thanks for reminding me of my crushing loss in the Supreme Court. I appreciate that.
But you got one vote in Morrison versus Olson.
Yeah, that's right. That's right. Let me echo my thanks that my co-panelists have offered to Michael and to Morgan for arranging everything and for putting together such a great program. Let me say a couple words about Clinton against Jones, and I don't want to relitigate the case, which is an utterance people make that means the opposite of what they say. It's like it's not about the money, which means it's about the money. Let me just say a few words about it without really trying not to relitigate it. First, something about, our argument was that a sitting president who was sued civilly, the suit should be stayed while the president is in office. The suit should not be barred. The claim could be, if it were dismissed, it would have to be dismissed without prejudice, and something would have to be done to adjust the statute of limitations. But the suit should simply be held in abeyance. So it was not an argument for immunity, although it was characterized that way, which was unfortunate. And it was a Section 1983 suit arising out of actions President Clinton was alleged to have engaged in when he was governor of Arkansas that would have constituted sexual harassment and therefore a violation of the constitutional rights of the plaintiff. The foundations of our position, and foundations maybe should be in quotation marks, partly for some reasons that Sai just adverted to. The foundations were two things. One was Nixon against Fitzgerald, which is, of course, the case that holds that a president is absolutely immune for actions he takes within the quote-unquote outer perimeter of his job as president. Now, of course, these were not within President Clinton's, was not something President Clinton did while he was president, but our argument was, look, if you get absolute immunity, you can't be sued ever for what you do as president, no matter what. Doesn't it make at least a little bit of sense to say that while you're president, any suit against you should be held in abeyance? And the other foundation was the OLC opinion holding that a sitting president cannot be prosecuted. The interesting piece about those two foundations, if that's the right word, is how they got to be foundational, and I think they are. Nixon against Fitzgerald is a 5-4 decision, a very strong dissent written by Justice White. There is a massive expressio unius problem with the conclusion the court reached, which is that members of Congress have an immunity right there in the Constitution. There's nothing comparable for the president. So you might think, well, that's a problem. But nonetheless, Nixon versus Fitzgerald seems to be sticky. It doesn't seem to be going anywhere. We don't see people challenging it. The special prosecutor in the Trump cases did not say, maybe Nixon against Fitzgerald, maybe the court should consider revisiting that. That was nowhere in the picture. Seems to be totally settled. And ditto, maybe even more surprisingly, for the OLC opinion, which isn't even a judicial opinion, but I think it's kind of revealing of the way our constitutional law works, that when you have a position taken by successive administrations of different parties, that's pretty good. That really means it's okay, it's settled now. And I don't think there's been any serious challenge to that. I don't think that that's really up for grabs either. So these positions, which have, in some sense questionable foundations, I don't think they actually do, but I think if you're looking for text, original understanding, standard principles of textual construction, and so on, it's hard to find a basis, really a size point. They seem to be foundational. So that was the basis of our position. I think in our arguments, we did a couple of things that we got wrong, a couple of things we got right that have implications for some current controversies. So let me say something about all of that. One thing that we got wrong was we predicted that, we told the court that if they allowed this suit against President Clinton to go forward, this tactic would become a standard tool in the repertoire of partisan warfare. I think I just mixed metaphors, but you get the idea. That what you'd find is political operatives going out, finding someone out there who had some previous dealing with the president and sue him. And that didn't happen. That hasn't happened. And George W. Bush was in business. There must have been some people out there who came up on the wrong side of a deal with him and were ticked off about it. And you would have expected, especially after the 2000 election was very contested, that some Democratic political operatives would be out there trying to find these people and sue President Bush and put him through discovery and go through his financial records. And even if you don't find anything, even if you don't hold him liable, you'd at least damage him. That didn't happen. Now, exactly why that didn't happen is a bit of a puzzle. But in fact, it hasn't turned out to be a principal weapon of partisan warfare, even though President Bush was probably vulnerable. President Trump did get sued, of course, but even there, it really didn't take that form. It didn't take the form of kind of a systematic effort by politicians opposed to him to find someone to put him through this process. So we got that, we were wrong about that prediction, at least so far. What I think we kind of got right, although it's in a qualified way, is this. One of the reasons for the court's decision, one of the points Justice Stevens made in his opinion for the court, was that district courts can manage this. That yes, it has the potential to disrupt the president's conduct of his office, but district courts can be attentive to that and can work around the president's schedule. And we had said in the briefs, look, you don't want to put district courts in that position. I mean, the president says, I need to be in this negotiation at this time, and the plaintiff wants to depose him, and the district court has to decide whether he can hold off on that diplomatic negotiation while he's deposed. That's just a terrible position to put district courts in. District judges really should not be put in that position, and it's not clear you can trust them, although we didn't spell that out. Justice Stevens, very confident in the ability of district courts to manage litigation. I think on that we were kind of on to something, although maybe ahead of our time. And I think there may be a broader lesson here, which is this. One of the things that sort of, for me at least, hangs over these issues about executive power is whether our thinking and the thinking of the courts was generated in an era that is quite different from ours because it was much more bipartisan. So it was generated in an era when President Nixon was forced out of office because the Republican leaders in Congress, people from his party, went to the White House and said, it's time for you to go. And that's what did it to Nixon. And we are not in that era today. And I think a lot of the sort of thinking that has gone into these issues is kind of stuck in that era. And I would include Justice Stevens saying, look, district judges, I mean, they're judges. They're gonna handle this stuff in a straight up judicial way, which may have been true then, but I think there's reason to suspect that now with the appointments process becoming as politicized as it has, that's no longer as strong a claim as it was when Justice Stevens relied on it in Clinton against Jones. So I think to that extent, to the extent we said, you really should not put district judges in the position of deciding this for everyone's sake. I think we were onto something there, even though we were mistaken about at least so far, about the usefulness of this as a political tactic. There's just one more point, and this really is kind of what sour grapes or something. Sour grapes, the opposite of sour grapes. We tried to be very careful to say we're not asserting an immunity, that this is just a suit will be deferred. It's not that extraordinary for a suit to be deferred. The automatic stay in bankruptcy means plaintiffs with good claims are going to have to wait until bankruptcy process gets sorted out. My understanding is that David Sklansky would know this better than I, but my understanding is that in a lot of instances in which there's both a prosecution and civil litigation raising the same issues, like securities fraud, that the civil component is stayed while the prosecution goes forward, because otherwise the civil litigation might interfere with the prosecution. It's just not that extraordinary to say to a civil plaintiff, you have to wait because there are other important things going on. One of the important things could be a presidential administration, but that we couldn't kind of get the court to see things that way. We did make the argument that Sai said he hadn't seen made, which is the argument that there's a statute that allows service members under certain circumstances to defer litigation this way. We made that argument in the petition, and certain segments of the press and the populace went crazy because President Clinton, on whose behalf this argument was being made, was alleged to be a draft dodger. And how dare he, just because he's the commander-in-chief, how dare he treat himself as a member of the armed forces? So we dropped that out of the brief, and I think we might even have said, we certainly said something publicly, and might even have said something in the brief that, oh, no, sorry. We didn't mean that, because the uproar was so complete. The person who was blamed for this was a lawyer in the White House counsel's office who was working with us on the case, and her career was ruined, actually. Her name's Elena Kagan. So yes, we did try that argument, but didn't work. Okay, just one last set of thoughts about this. One place where Clinton against Jones had an influence was in Trump against Vance, which was a effort by a state prosecutor, the Manhattan District Attorney, to compel President Trump to disclose certain documents because he's under criminal investigation. Trump sued to join the investigation. The court entertained the suit and gave him an exception to arguing against Harris to entertain the suit, but ultimately ruled against him, and really in an opinion that gave very little ground to Trump. Basically allowed wasn't an unequivocal victory for the state prosecutor, but a pretty substantial one, relying on Clinton against Jones, which I think is right. I think the outcome in Trump against Vance in many ways follows really a fortiori from Clinton against Jones. It was a matter of providing documentary evidence, not even sitting for a deposition, much less being threatened with liability. And ordinarily in these instances, the government's interest in pursuing a criminal matter is stronger than a private litigant's interest in pursuing a civil matter. People performing judicial and prosecutorial functions have absolute immunity from civil suits, but they do not have immunity from criminal prosecutions. And of course, the relationship between Nixon against Fitzgerald and presidential immunity from criminal prosecutions is at issue now. So I thought Trump against Vance really did follow, and the court thought about it the same way. But as far as where that leaves criminal immunity, just a couple of thoughts about that. I think there is a case to be made, and I actually thought that the special counsel's appellate advocate, Michael Dreeben, made it well, that you don't need an immunity here because there are plenty of safeguards for the president, three in particular, that do not operate in the context of civil litigation ordinarily. One is that government officials have lots of privileges to engage in conduct that would otherwise be tortious or criminal. Law enforcement officers can do things that would otherwise be assaults and batteries because they're privileged, because they're engaged in their law enforcement functions. The same thing would apply to the president. Now, of course, he'd have to show that sort of meet the criteria for the privilege, but it's not as if someone can just pop up and say, "Oh, you authorized this law enforcement action, and that a prosecutor could prosecute a president for some crime because of a law enforcement action the president authorized." There are scienter requirements in criminal statutes. And the other thing is that a president can argue that what he was doing was within the scope of his powers under Article 2, express or implied powers that belong to him. Now, there'd be a question whether it is within the scope of those powers, whether the kind of military action he authorized really was something that's within the power of the commander-in-chief to do. But that would be an argument. It would be a Youngstown-type argument, and the president can rely on that. So there are those barriers that I think exist in the criminal context, and that's why I think that even had Clinton against Jones come out the right way, the other way from the way it did come out, that the case for a immunity against criminal prosecutions would still be pretty weak.
So in about 10 minutes or so, I want to turn to questions from the audience, so think about what you'd like to ask our panelists. But before that, I'd like to pick up on one of the points Professor Straus made about the way in which politics in the United States has changed over the last 10 years. And I want to ask the panelists to reflect on how much that should affect how we think about these questions, to what degree we should be looking for principles that are responsive to our current politics, and to what extent we should be looking for principles that transcend our current politics. And I'll just to put maybe a finer point on it, Professor Straus mentioned that in the years since Clinton versus Jones, it hasn't turned out that civil suits have become a standard part of political partisan warfare, civil suits against a sitting president. Up until 5 years ago, I think there would have been broad agreement that was true also of state criminal prosecutions. But there's a significant part of the country, including a number of elected members of Congress, who clearly think that we're not in that era anymore. And so I'm just wondering how the three of you think about how much where we find ourselves today should affect the way we think about these questions at the intersection of presidential powers and prerogatives and the civil and criminal legal systems.
Well, that's a great question, David. I think my intuition, will be different than everybody else's. I don't think it should matter. I think either the Constitution grants these privileges or it doesn't, and it shouldn't turn on whether the presidency is under attack by litigation or prosecutions. But I'm confident that the court will disagree with me. And so I just think it's just a mistake to think about the world in that way and to change doctrine that way, because it might imply that later on we get rid of them if there's no threat. But Justice Alito said in the Vance case that David cited earlier that the president couldn't be prosecuted while in office, and that wasn't even an issue in the case. He went out of his way to say this was not permissible. So I'll leave it at that.
I think it's a great question. I think it's an extremely hard question. It's very difficult to sort of step outside where you are in history and sort of try to decide things and try to figure out, are you overreacting to the specific circumstances you're confronting, or no, those specific circumstances are things you have to deal with, and your view about these issues is too rosy because, as I suggested earlier, was really colored by sort of things that happened when you first started thinking about these, or an era that you're sort of happier thinking about when things weren't troubled, at least troubled along certain margins. Every year is troubled along some margins. So I don't think there's any kind of an across-the-board answer. I mean, my inclinations in these matters is really, size, great, and I always learn from reading his stuff, but it's almost the exact opposite of size, which is make small adjustments. That's my inclination. Don't sort of jump. But if you're kind of proceeding along one path and you run into something and you think, this isn't really working, you don't jump to the opposite position. You make a small adjustment. You do a little bit. And so in the case of the prosecution of President Trump, my inclination, I don't know how to make this very concrete, my inclination would be to open the door to that and try to limit it and try to hedge it and make sure it's bounded and see what happens. And if things work out okay, then maybe open the door a little wider the next time this comes around. And if they don't, then back off. But I think that would be my general inclination of how to approach this. But it's a notoriously, I think, a sort of a tough problem.
Okay.
So I would say, again, with the focus on the states have primary responsibility for this thing we call the police power. Most crimes are happening at the state level. Most crimes are getting prosecuted in the state courts. So when anybody who is within the jurisdiction of the state violates criminal statutes that are pre-existing, right? We've ex post facto restrictions on creating new things to address concerns after they've happened. I think it would be a massive step for the Supreme Court or any federal actor to tell the states that they suddenly do not have the same jurisdictional reach in their criminal law and police power as they thought they had, simply because the defendant was extremely high profile. I think that the one challenge, and here Sai had said something about sitting presidents can be indicted, it would not be as disruptive. I think your point is a good one, that the vice president can, of course, take over if the president becomes incapacitated. I think a president would probably also argue that the incapacitation extends to not from the moment of indictment, but from the moment the trial begins, because he literally can't do anything else for 8 hours a day while he's sitting in the courthouse. So that does create, even if he ends up being convicted and then put on probation during the period that he's subject to trial, the state is fully exercising jurisdiction over his body and his time and his calendar in a way that I think would need to be addressed. I don't think it means they can't do it, but it would certainly need to be addressed. But I do, this is sort of a side commentary. As much as I think there are some supporters of President Trump who for the first time are saying, wait, what? Are criminal courts do this? Prosecutors can just levy charges against people and require people to show up to be booked? I do actually think there are a lot of people who exist in in the opposite side of the criminal law and procedure sphere who spend a lot of time thinking about how big the footprint of the justice system is, and that we ought to be much more sparing in our use of pretrial detention, and we ought to be very concerned about prosecutor overreach, and yet they are cheering for full prosecution of President Trump. Suddenly, like, all of the commitments to smaller footprint, less use of pretrial detention, when you have a defendant who has been accused of what he's been accused of, those core principles seem less stable, perhaps, than they might otherwise be. So I guess I'm a person who believes in articulating a principle, and that principle has got to apply no matter who it is being applied to. So I do worry, I think, both on both dimensions, that if we have the Supreme Court or some federal actor saying, well, presidents are too important to be subject to the rules of the criminal law, that then we have a president, as I believe Donald Trump did before he was elected, saying something like, I could shoot somebody on Fifth Avenue and I would not be in trouble for that. Maybe he said I would still be elected. I think the point is he needs to still be prosecuted for that, or everything about our criminal legal system will collapse.
So I want to ask David and Sai if either of you want to address the federalism issues that Kay raised and talk about how that affects the points that you were raising earlier.
I mean, I'll say that, going back to what David said about there's a consensus that the president can't be prosecuted. There won't be if Donald Trump gets elected, because the state prosecutors won't follow the OLC opinion. They're going to deny it. And immediately half the country will deny it as well. I mean, they won't necessarily have had a position on it beforehand, but they'll have one after he's president. So I mean, I think things are foundational until they're not. And I don't really think the OLC's, again, I think the court will agree with the OLC's opinion, but I don't think it's not obvious to me that the state prosecutors will, or the state court systems. It might have to go all the way to the Supreme Court to get the result that the OLC suggests. I think if you think that Article 2 itself gives some sort of immunity from criminal prosecution, you're going to think that's true vis-a-vis congressional statutes or state statutes. If instead you think the lack of prosecutability for a president's official acts comes from a lack of congressional power, you'd have to have some other principle why states couldn't do it. And so for that reason, it might be more attractive for some people to find the immunity arising from the implications of Article 2 rather than from the lack of congressional power to create a federal crime in this area.
Yeah, just two thoughts. I mean, it's just a matter of prediction. I think Sai's right that there's no reason to think every state prosecutor is going to just lie down in front of the OLC opinion and say, yeah, OLC said it, that's good enough for me. I do think if it, push came to shove, that the OLC opinion would turn out to be the law, but that's obviously speculative. In Vance, the court kind of went out of its way, to David's question, went out of its way to sort of deal with the federalism issues. It even kind of set up a cause of action for presidents to bring to, if they thought that state prosecutors were interfering with their functions. And ordinarily, a criminal defendant can't do that. Ordinarily, you got to wait for the prosecution to go forward and raise it as a defense, but it's sort of spelled out presidents can do that. So there's a little bit of protection there. Beyond that, I'm not sure how to think about it. But just related to what David's question and Sai's point, and especially to what Kay's been saying, this is also a preview of coming attractions, which is Jack Goldsmith's talk at lunch. One underrated check on prosecutors comes from the prosecutor's office and the bureaucracy in which a prosecutor is embedded. This was what the attorneys general in the Morrison against Olson in the amicus brief I wrote were saying, that having someone having to deal with bureaucratic constraints, which is to say, if you get obsessed with a prosecution, a federal prosecution, say, the FBI special agent in charge is going to say, what are you doing? Why are you spending all these resources here? Or your fellow prosecutors will get upset and your boss will tell you to back off. Or if you begin to intrude on other functions of the federal government, that those people will complain. And those are important checks, just being embedded in a bureaucracy where you've got to answer to other people besides just yourself. And that's one of the problems with independent counsels, is they don't have those checks. So I think that is a sort of an often underrated part of this system that provides a little more balance than we might think.
So before we take questions from the audience, I'm wondering if any of the panelists have questions for the other panelists. You think we should go to?
Yeah.
Okay. So maybe, yes, sir. And then we'll go. No, go ahead. No, I don't know who's there first.
Okay, I'll go first. So from my point of view, this is the best session of the whole thing. So I'm going to follow up to what David's first question made. So are you guys familiar with a guy whose name is Harvey Silverglate? He's the co-founder of FIRE, the Foundation Foundation for Individual Rights in Education. He wrote a book called 3 Felonies a Day. His main argument was that any one of us, because of the way the laws are written, because they're written long ago, because they have never been repealed, because the way the legal system is actually being built, the federal system, each of us could be charged with 3 felonies just in our current. So my question is, haven't we crossed the threshold where any president in the future with a zealous prosecution could be charged with a felony that is totally made up? Because both Jonathan Turley and Alan Dershowitz, they believe, and I trust their judgment, that all the cases are manufactured. Particularly the documents case in Florida is manufactured. The one about the election interference is also manufactured. So all the cases that criminal charges against Trump are manufactured, and that sets a precedent for future presidents that will happen to any president who,
Okay, so I guess maybe we should start with you, Kay, because the question really is, I take it, is the problem here a problem that reflects in large part a pathology of criminal law?
That's right.
Yeah.
Yeah, I mean, right, you've gotten to, that's the point about prosecutor overreach. But just so everybody's clear, prosecutors and legislators have been in bed together on this for decades. That is, legislatures draft very broad laws with the consent of prosecutors to create these very broad laws so that prosecutors end up with all of the choices about whether to trigger a prosecution. And if they want to trigger a prosecution, once something has been reported by the police and so on, they get to decide from a very wide menu of charges, some felonies, some misdemeanors, some with state prison time, some with just probation time. Prosecutors have all of those choices, and legislators have given them those tools. This has been, and prosecutors often are lobbying behind the scenes to get more tools. So the problem of prosecutor overreach extends to a whole lot of people. I mean, it's people's behavior in the population. Presidents are, to me, one tiny slice of that. In terms of who I would spend my time working on behalf of to make sure that prosecutors are exercising their powers widely. Those powers are not going to go away. The idea of that we ought to be protecting presidents from this is only a very small part of the equation. And I think, right, so as we think about the principles that ought to guide.
But to the extent that it interferes with in the US we had this law, we don't have it anymore, but we had this norm and region that we don't use lawfare against political opponents. And the optics of this is Joe Biden is weaponizing the federal criminal system to go after his main political opponent. And that's an optics problem that I understand that you guys are experts in the law, but for a regular person like I am, that's what it looks like from the outside.
I saw it. I'm sorry, did you want to say something?
Yeah, no, I was just saying that I think the claim that a prosecutor might be bringing charges against a person for other than pure motives, right? That is has been longstanding, right? I mean, putting the presidential politics part of it aside, there are a lot of defendants who have been prosecuted for a lot of things over the course of the last many, many decades who believe they have been specifically targeted. I want to take it out of the politics realm for a second and say that our constitutional doctrines that limit the prosecutor's decision to bring charges against somebody are extremely stingy. And they are stingy because of the Supreme Court. So we have equal protection as a doctrine. In prosecution, we call that selective. The doctrine is selective prosecution. What it takes to prove, for a defendant to prove an allegation of selective prosecution, it is nearly impossible. Nearly impossible. And it's limited generally to the categories that we think of for equal protection categories. So race, religion, gender, union membership, and so forth. But it's almost impossible to prove. We have double jeopardy, which prevents a successive prosecution for the same crime. The Supreme Court has defined what counts as the same crime or different crime. in the smallest, narrowest framework possible. So these are just a couple of examples. If the Supreme Court and the federal courts generally were more interested in limiting prosecutor choices, they could have a very different take on these constitutional provisions. We could see state and federal statutes that impose limits on what prosecutors can do. So far, none of the other branches, the courts or the legislature, has expressed any interest at all in limiting what prosecutors are doing. The limitations we see emerging right now happen to be in red states where there are blue cities, where there are allegations that the prosecutors in the blue cities and blue counties are being too lenient, not too aggressive, but rather too lenient. So for prosecution scholars such as myself, that's ironic that there have been examples of overreach and even abuse for decades, and legislatures have turned a blind eye.
So I want to get to the next question, but before I do, I want to ask Sai and David, as people who've spent a lot of time thinking about presidential powers and prerogatives, what do you think of the idea that in this context, when we're talking about the collision between presidential powers and prerogatives and criminal law, the repair work really needs to be done in criminal law?
I think I'm out of my depth. I defer to Kay about the criminal law. I will say that I think it can be true that the president doesn't have any immunities from prosecution, and also be true that the people prosecuting him have corrupt motives, right? So I don't have to disagree with the person's question. I think that's quite possible. I mean, I think the New York prosecutor ran on a platform of saying, I'm going to get the president, which is not a good look for a legal system to have, right? To have people running for office saying they're going to prosecute a particular person. Ian Ayers and I have an article about this where we suggest that there ought to be some additional procedure composed of former prosecutors who decide whether sitting presidents and other high government officials ought to be prosecuted. Because we do have the view that this portends a future that's rather bleak of partisan prosecutions going both ways. And part of the paper actually tried to seek the opinions of former U.S. attorneys about the 4 different prosecutions against President Trump. And the reactions vary across the prosecutions, with the Florida prosecution being viewed as the strongest and the New York prosecution being viewed as the weakest. Not even 50% of the people who responded favored the New York prosecution. And so I think it's useful because in some cases you had Republicans who favored the prosecution and Democrats who disfavored it, depending on the prosecution, which suggested that these people were committed, at least there was some evidence they were committed to a rule of law framework and not just focused on whether it was Donald Trump or not. But I do fear, whatever the constitutional question is, I do fear that this is going to happen more frequently. And of course, Republicans are saying they're going to now engage in the same kind of, retribution against Democratic officials.
Yeah, I guess my sort of ill-formed thought is that the issue really is not so much about presidents, because the prosecution of a president is so high profile, attracts so much attention, that they're kind of built-in checks. But the politically motivated prosecutions against other officials, federal or state or local, that there's a bigger issue there, that prosecutors will abuse their power for political reasons in that way. And the pushback against that, to the extent it exists, is actually, this is kind of it's sort of in what Kay said about the kind of the way that the legislatures and prosecutors work hand in glove. The pushback there actually seems to be coming from federal courts, very much including the Supreme Court, being increasingly hostile to white-collar prosecutions, often in ways that protect federal government officials who've done some pretty shady stuff. But, the statute doesn't quite seem to cover it, or if the statute covers that, it also covers lots of innocent stuff, so we can interpret it to cover that. So I think that's kind of the back and forth at this point. Not, as I said, not so much presidents as other officials, where there is a real danger, and the reaction being to sort of cut back on white-collar prosecutions is probably not the way to deal with that, because it might let too many corrupt people off the hook. But that's where I see the sort of interesting and possibly troubling dynamic taking place.
Thanks. Okay.
Yep. Well, thanks for the interesting discussion. I don't want to belabor the point, but I had sort of a version of the same question. I was wondering if if we have a problem of kind of changed circumstances, greater incentives for prosecutorial abuse, would it make sense to have a more robust kind of selective prosecution doctrine to say, you know, prosecutors can't pursue crimes that they wouldn't pursue against other defendants, or is that not workable partly because presidents do things or other political officials do things that ordinary defendants don't, so you can't, there's never really a neutral comparator in making those assessments?
So I think we have to start again with you. Pam.
Yeah, so anytime we're making an equal protection argument, we have to identify the control group, right? Like, who are the similarly situated defendants who could have been treated this way but weren't? So your instinct, I think, is right that presidents, there is a very small n, right, of like the number of other presidents who were similarly situated in terms of we knew that they engaged in this behavior and that they were not pursued. But it's also not pursued by just anybody, but by this particular prosecutor's office. So in selective prosecution, we tend to be limited by claims of race and gender and religion and union membership. It's never been extended to somebody who, like, in a political office sort of way. So, but I think your instinct is a good one, which is if we identify a core problem as, let's say, a particular prosecutor's office being politically motivated in a way that has a corrosive effect on the integrity of the system, maybe it's time to make some adjustments to that doctrine. Courts generally, though, are really reticent to take a look at the subjective motives of members of the law enforcement team. And here I'm including police as well as prosecutors. They just don't like it. So you have statements from the Supreme Court in particular saying, as long as there's probable cause, that's all we care about. For police, there's a case involving police where the claim is basically we don't care if the police officers were racially motivated, they're misogynistic, xenophobic, anti-LGBT, none of that matters as long as there is probable cause, objective facts and circumstances that support taking the action. So I think in order to make the kind of adjustments to the selective prosecution doctrine that you are, I think, rightfully concerned about, the court would have to walk back a lot of those other opinions on pretext and its unwillingness to examine the motives of the law enforcement team. My reasons for optimism on that are few, I'll say, given the current Supreme Court.
David, Si? I'm wondering whether another way that the selective prosecution doctrine would have to be changed is we'd have to loosen up the requirement that you have to find comparable cases. Because one feature of many of the cases in which you worry about politically selective prosecution is that it's hard to find another case that looks exactly like it. You know, when former Governor Don Siegelman was prosecuted for bribery, it was very difficult to find another example where a governor had said, if you contribute to this fund for public schools, I'll put you on a commission. So it's hard to find comparables, and that's I think it reflects a general feature of our system that we give very, very broad deference to prosecutorial determinations of when the criminal law should be applied.
Well, I think probably the search for comparables becomes much more searching, right, with white collar, because if your comparable is selling cocaine on the street corner, there are 50 other cases that you could point to from that month in the jurisdiction. But if you start to parse the particular facts of bribery, instead of just bribery more generally, like then it becomes a lot harder.
All right, so I know we have some additional questions, yes.
Yes, sir. We live in a time of a lot of controversy, and that's not surprising given the issues that are under discussion, because notice there are going to be issues that divide people. The role of parents versus the role of schools and government in deciding appropriate things about gender, sexuality, and what have you. There's going to be a lot of controversy. And politicians have thought of creative ways to garner a momentary edge. Like, notice in 2015, there was a move, well, it's the last year of this administration, we should wait till the next election before we appoint, make a Supreme Court pick, so the new president can be the one making the appointment. There's never been an issue before where there was a decline in presidential authority as you moved closer to the end of your office. And in terms of prosecutions on crimes, this is obviously going to be a tool people will use to prosecute those who have gone farther than other politicians before. And that's a case we might have presently. So there's going to be a lot of challenges because there's a lot of issues we've never faced before. Like, how many people do we let cross the border in a month historically, you know, compared to the average for, say, the past year? Anyway.
So I guess this brings us back to the question of what do we make of the current state of our politics, and what implications does it have for whether we should reconsider Clinton versus Jones or the LSC's longstanding position on the immunity of sitting presidents from criminal prosecutions, or any other thing that we've taken for granted. I'm a law professor. I can call on people.
I'll defer to both of you because I said the last one.
David, why don't you start?
Yeah, I mean, we've sort of circled around this question in a bunch of ways. You know, one of the under, I think, studied aspects of the way our legal system works, constitutional law and other kinds of law, as well as we have this balance between trying to sort of say, well, here's some general principles, and as the Supreme Court, as Justice Gorsuch or someone said in the argument about immunity, you know, I'm doing something for the ages, which is probably not something you should say, even if it's what you're thinking. Versus, you know, the case before you, decide the case before you, you know, figure out how this case should come out, and you have to try to keep those things both in the picture. There was a period after Brown against Board of Education when even people who applauded Brown against Board of Education, the outcome, criticized the court for not being able to articulate a neutral principle, was the phrase. Partly in Brown and also in some of the other cases of the Jim Crow era involving things like racially restrictive covenants and white primaries. And I think one of the lessons of that is both sides there's a trap on both sides. There's a trap in being so caught up with the immediate facts, you know, hard cases make bad law and all of that. And there's also a trap in thinking, well, if I can't kind of work out a fully formed set of principles to deal with this problem, I shouldn't address the problem. And I think both of those are failures, and I think you sort of have to do the best you can and hope that over time you can work out a principle. So that's why my response to sort of the current things would be, you know, let's take a crack at it, and if we think that sort of the sort of Trump administration and Trump's behavior has identified some problems in our system, or at least if not in the system, maybe even not in the system, but in our civic culture, let's try to address them and be prepared if we need to retrench and retreat and rethink. But for now, let's try to address them, even if we can't quite figure out a way to say, here's a principle for the ages. That would be how I'd come at it.
And I mean, I think I would just add that people in the United States have a long history of using the criminal legal system as a trash can. Problems that are hard to solve, intractable problems, seem to get dumped on the desks of members of the law enforcement team, the prosecutor's office, the criminal courts, et cetera. You know, told, like, you solve this, handle this. So vagrancy statutes were used in the 1920s to address union organizers who were rabble-rousers and the corporate owners of railroads and things that didn't like the fact that union organizers were trying to organize strikes. In the 90s, statutory rape became the crime of fashion to address the intractable problem of teen pregnancy. So I think one of the lessons I think that we maybe all should take is when we think about the prosecution of Trump, do you think that the problem of the prosecution of Trump is the breadth of the statutes that can technically be used to cover the behavior of which he has been accused? And if you think that's a problem, then the solution lies with the legislature to design and tailor statutes to be much more specific about the core of the behavior that we really want to address. If, on the other hand, you think that the problem of Trump is that he was running wild and that the only people who can solve this, the political system, is not going to solve it, so we need prosecutors to solve it. Prosecutors are willing to jump in, some prosecutors are willing to jump in and use their power to try to solve this problem that has been placed at their feet. That calls for a different kind of solution. Maybe in that case, you want prosecutors to have more power. We want to make sure that presidents in this spot don't just claim random forms of immunity for which there is no constitutional or statutory basis. So identifying what the problem is where these two things intersect leads you to a different pathways for solutions.
Can I just, what Kay said about the criminal justice system being the place where we go and we can't figure out how to solve a problem. The war on drugs, right?
Yes, right.
A terrible problem of drugs. So what do? We
Criminalize.
We criminalize it.
Homelessness.
Right,
Yes.
right.
Yeah.
Sai, do you want to weigh in on this?
I think, just to maybe respond to something that David said earlier about, the internal checks in a prosecutor's office being stronger when you're going after a president or a former president, but weaker for other officials. My intuition might be the opposite, because I think if you are a prosecutor, the biggest trophy on your wall is getting the president, not some low-level official. And of course, rightly or wrongly, presidents who've been in the bullseye or been targeted have claimed that the offices are populated by people of the other party with a vendetta against the president. And I think there's some ring of truth to it. And then, in thinking about maybe Jack will talk more about this, but thinking about the prosecution in D.C., I think the charges just turn on the claim that he didn't believe that he won the election, which of course is possible. But people have submitted, what I'll call false slates of electors before and done, challenged all kinds of things before and never been prosecuted for it. And I guess it's possible that no one will make these claims anymore because they're afraid of being prosecuted. But I do think there's a sense in which this special prosecutor is not merely applying existing law, but attempting to read existing law in new and inventive ways that you might not think would have been done but for Trump. And I think the same thing could be said of the New York prosecutor, right? Is the end there former presidents, or is it all businesses who seek loans from banks who inflate the value of their property? I would have thought it was the latter and not the former. And if it is the latter, you might think it does look like they're going after one person who's inflated their property values in order to secure loans. That's at least a possibility, and it's consistent with the claim that I will get Trump if you elect me to be the prosecutor, which again is absolutely terrible.
So I think we have time for at least one more question.
I want to ask a question about something that Professor Prakash suggested earlier, where if there was no structural immunity, Congress could step in and fill the balance. I'd be curious why, if we went that route, Congress would have the power to preempt state prosecutions, especially if they're outside of kind of official actions. Makes sense as kind of a limitation on federal criminal enforcement, but be curious to hear your thoughts on kind of the federalism aspects and the enumerated power that might justify that.
Well, if it's a question for me, I think if we're looking at what Congress has done in the past, as David said, there's that Soldiers and Sailors Act, which I think does apply to state court actions against members of the armed forces. But I think the more general point would be, look, we think these sorts of suits, whatever the category is, interfere with the president's business such that we think they should be deferred until the president's no longer in office. And the source of the suit doesn't matter, whether it's federal or state. Obviously, if it's federal law, Congress can create an exemption apart from equal protection concerns, right, which I don't think would apply. And then for the state suits, it would just be that they're as equally diverting as the federal suits, and we wish for the president to spend his or her time on federal matters, understanding that, of course, they will play golf and do other things as well, but still, right, that we don't want them to be focused on these matters. And so I think it would be necessary and proper to carry into execution the president's powers to give them that immunity, just like it's necessary and proper to give a more limited form of immunity for members of the armed forces. At least that would be the argument.
Yeah, I think, I mean, as I was saying, the necessary and proper clause applies not just to Congress implementing its own powers, but implementing all the powers of the Constitution. And it's a pretty straightforward argument that this is necessary and proper to enable the president to do his job. I should say along these lines, and one of the puzzles in this area is the extent to which the existing immunities are constitutional. It's not clear that the Nixon against Fitzgerald immunity is constitutional and could not be overridden by Congress in size scenario. The court actually, if I remember correctly, I haven't read the opinion for a while, specifically set that aside, whether Congress could authorize civil actions against the president. Nixon against Fitzgerald itself was a Bivens action, basically doesn't exist anymore, but whether Congress could authorize an action despite and override the immunity, I think is an unsettled question. I think everyone's instinct is it is constitutional, but we don't know that for sure.
Thanks.
Okay, do you want to add?
Not good.
So,
Can I just
You have a
throw
question
one
from the-
thing in? This is not a question, but just one aspect of this that I think has not been mentioned, which is supremacy clause immunity. It's a really bizarre corner of federal courts. But if a state prosecutes a federal official for an official act, that federal official can remove to federal court, at which point I would think the federal judge might pay more attention to the OLC opinion than the state prosecutor would.
So I would say that's possible, but again, with removal, it is still a state prosecution. It's just taking place in the federal courthouse. So state charges, state prosecution. I think you're right that the federal judge may have a greater affinity for the OLC opinion than a state court judge would, but I would expect the state prosecutor's office to argue just as vigorously to keep their prosecution alive.
well, Professor Levine has to get to the airport, and many other people need to get to lunch. So would you please join me in thanking our panel for this terrific discussion?
That was fun, as always.
That was